Ms. Ross, you're recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you to all the witnesses for testifying. And I'm thrilled that I went after Mr. Roy because we agree completely on this. The problem of qualified immunity goes well beyond the police. As a former civil rights litigator, I actually rarely sued the police. I sued lots of other people, and they invoked qualified immunity. And so we should be addressing this problem writ large. Many examples in the public mind right now involve the police, and we shouldn't exempt them from any change in qualified immunity. But we have had egregious situations in North Carolina with the Department of Social Services. We've seen egregious situations with sexual misconduct and treatment of women. We've seen egregious situations with racial discrimination and discrimination against immigrants. And all of those issues should be on the table today. As we know, the doctrine of qualified immunity protects state and local officials, not just the police, where they can only be held liable for violating somebody's rights if a court has previously ruled that the actions are unconstitutional. The actions, and therein lies the problem. If no decision exists, the official can be immune from liability even if they intentionally violate the Constitution. Qualified immunity acts like a time warp. In its current form, the doctrine allows conduct to be judged by completely outdated standards and parts of our history that we are trying to rectify. It doesn't let us rectify history. Public officials should not be allowed to avoid the consequences for egregious actions by hiding behind judicial opinions that previously found conduct acceptable. The actions of law enforcement and other public officials must be judged under evolving standards of what constitutes constitutional conduct, not decades or centuries old endorsing of unconscionable practices. My first question is for Mr. Schweikert. In your written testimony, you cite several cases in which qualified immunity was granted because the cases differed just slightly from clearly established precedent. In the interest of time, I'm not going to go through a couple of them, but my question is, how has the clearly established law test stunted the development of constitutional law?
Thank you very much for the question. It has stunted the development of constitutional law because the Supreme Court has held, as Mr. Mangle has previously discussed, that courts are allowed to dismiss a case by saying, well, we're not even going to decide whether this was constitutional or not. We're just saying it's not clearly established, so qualified immunity case dismissed, which means the law then does not become clearly established going forward. And so this is why Judge Don Willett has called qualified immunity a catch-22. And it means that, in fact, the exact same misconduct could be committed the very next day, and again and again and again, it could still be excused based on qualified immunity because courts refuse to decide the constitutional question, especially in the most difficult cases where clarification of the law is most needed.
Thank you very much. And Mr. Ago, we got a great example from Mr. Roy earlier of local officials who violated constitutional rights but were granted qualified immunity not in the law enforcement context. Could you share with us other examples outside of the law enforcement context?
Thank you, Congresswoman Ross. The Lawyers Committee is concerned about law enforcement because of the devastating and differential impact of police abuse and misconduct against communities of color. That said, there are substantial numbers of examples outside of the law enforcement context where, for example, public school teachers abuse their power. Situations like what you mentioned, Congresswoman Ross, social workers abuse their power and violate the constitutional rights of the people that they're supposed to be serving. So that there are lots of examples outside of law enforcement. The Lawyers Committee's concern is law enforcement, though.
And to our distinguished judge with my last 16 minutes, if we, 16 seconds, I'm sorry. I wish I had 16 minutes. Would your solution deal with this broad problem much more effectively?
Yeah, the answer is yes. I think it would make it an effective remedy, and I think it would make it a modification that has some chances of being enacted. And from the controversy I've heard today, I despair that as what happened 30 years ago when I testified to you, nothing happened. So I think you ought to consider municipal liability, employer liability generally, in order to get something done about this problem.
Thank you, and I yield back.
I am going to yield the chair to Congressman Ross so she can have the opportunity to introduce and recognize her distinguished colleague.
Ms. Garcia, you are recognized.
Thank you.